This microtalk is part of a mini-series on intellectual property ownership. We encourage you to watch the entire mini-series available on Springboard. Thank you.
Now, we've talked about copyrights and patents, but what about trademarks and trade secret rights? For the most part, those rights arise from the activities of the company itself. For instance, trademarks are used by the company on its products or services in commerce, and as a result, the company becomes the owner of the trademark rights. Similarly, trade secret rights arise from using reasonable measures to protect the secrecy of valuable non-public information, and a company can therefore establish its own trade secret rights by the way it handles and protects the valuable information it possesses, rather than needing to obtain trade secret rights from individual personnel. Also, employees owe a duty of loyalty to their employers, which typically prevents them from claiming individual ownership of trademarks or trade secrets that they help generate or that they learn on the job. So when you're dealing with actual employees, assignments of IP rights technically aren't really needed for trademarks or trade secrets. That said, careful contracting can certainly help to strengthen a company's ownership of its trademarks and trade secrets. For instance, thoughtfully drafted confidentiality provisions in employee agreements and handbooks, and consistent use of non-disclosure agreements when dealing with others keeps others from claiming ownership of the company's secrets. And they're also an important part of the company's reasonable measures to maintain secrecy, which are prerequisite for claiming trade secret rights. And with independent contractors and other non-employees who might be involved in generating trade secrets, you'll want your contract to be clear that they're creating that information for the company, that they're transferring to the company any rights they may have in the information, and that they'll protect the confidentiality of that information, not use or disclose it without authorization. And by the way, watch out for reciprocal confidentiality obligations in a contract that might actually restrict how your company can use or disclose information you're paying contractors to create. Don't want to let those slip through. I've touched on a number of points that come into play for establishing and documenting a startup's ownership of IP rights. Of course, you don't need to own IP in order to use it. In fact, US law has concepts such as shop rights, which allow companies to practice patents on inventions made within the scope of an employee's duties, or implied licenses to practice the copyrights in works made by contractors for the company, even if the IP isn't assigned to the company. So generally speaking, if you paid for IP to be developed, you'll most likely at least be able to use it if your contract doesn't say otherwise. But if you want to control IP as its legal owner, including the right to stop others from using or misappropriating it, please remember that careful contracting matters, especially for copyrights and patents. And we paid for it, so we own it, only gets you so far. Hope you found these observations to be helpful. To learn more about IP and other topics of interest to startups and their investors, I invite you to visit Mayer Brown's Emerging Companies and Venture Capital portal, Springboard. And thank you for listening.